The Senate Committee on Natural Resources will now come to order. Will the Secretary please call roll? Please mark Senator Goicoechea absent excused, and please mark Senator Scheibel present when she arrives. There are 3 members present, so we do indeed have a quorum. Before we begin, we would like to mention just a couple comments, housekeeping comments. A few reminders before testifying today for Senator Hansen. Please sign in at the table by the door. Please remember to state your name and spell your name when you do make it to the microphone. And also, we'll be taking public comment at the end of the meeting. I'll be limiting public comment to 2 minutes per person to ensure that everyone who's rushing into this room today gets the opportunity to speak. Please feel free to provide any additional comments in writing to the committee secretary, and they will be added to the record. All right, today we're going to be hearing 2 bills, and we'll be holding a work session on 1 bill previously heard by the committee. And with that said, we will begin the work session. I'd like to remind everyone, we will not be taking testimony at the work session. However, I may call someone forward as necessary to answer any questions from the committee. We'll now begin the work session on Senate Bill 76, and our policy analyst, Elisa Keller, will be walking us through the work session. Ms. Keller, please proceed.
Thank you, Chair Bazina. Elisa Keller, Committee Policy Analyst, for the record. The committee has 1 bill for consideration on work session today, Senate Bill 76. The work session document has been posted on Nellis. And Senate Bill 76, sponsored by Senator Dina Neal, was heard by this committee on February 21st. Senate Bill 76, as introduced, prohibits the sale and distribution of certain products containing intentionally added per- and polyfluoroalkyl substances, also known as PFAS, and requires a manufacturer of cookware that contains intentionally added PFAS to include certain information on the product label and on any product listing for online sales. Finally, the bill provides that a person who willfully and knowingly violates certain provisions is subject to a maximum civil penalty of $1,000. The committee will recall that 3 conceptual amendments were proposed at the hearing. 1 additional amendment was proposed by the sponsor after the hearing. Copies of the 4 conceptual amendments proposed are attached to the back of the work session document. So in summary, number 1, the Toy Association proposed replacing the term children's products with juvenile products throughout the bill. Merck, Sharp, and Dome LLC proposed adding certain exceptions to Senate 16 of the bill for drugs, biologics, medical devices, or diagnostics used to treat or administered to animals under certain federal acts. And number 3, State Medical Technology Alliance proposed replacing the terms approved or authorized with regulated to provide that the term product does not include any drug, medical device, biologic, or diagnostic regulated by the U.S. Food and Drug Administration or the U.S. Department of Agriculture. Following the hearing, the bill sponsor, Senator Neal, proposed an additional conceptual amendment, which is also attached to the back of the work session document, to add a provision to Section 11, providing an exception for the use of recycled raw materials which potentially have a legacy presence of PFAS, delete the language "or whose brand name is affixed to a product" from the definition of a manufacturer in Section 12, provide in Section 24 that a manufacturer of certain products must include a statement in Spanish and English on the product label that no PFAS are intentionally added or used to make the product, and add provisions to Section 24 providing exceptions for new products with PFAS present due solely to the use of recycled content and for textile products manufactured or imported prior to the effective date. Thank you.
Thank you so much, Ms. Keller. Do we have questions from anyone on the committee? Seeing no more questions, I'll entertain a motion to amend and do pass.
So moved.
Thank you so much, Senator Flores. Do I have a second?
Second.
Thank you so much, Senator Hansen. I have a motion and a second. Any discussion on the motion? All right, all in favor, please say aye.
Aye.
Any opposed? Wonderful. Thank you so much. And because of the challenging pronunciation of PFAS, I think we're going to assign the floor statement to the sponsor and our colleague, Senator Neal.
Madam Chair, I did challenge her to spell both of those words, and she refused, so.
Thank you so much. All right, we'll now open the hearing on Senate Bill 141.
If I could, I'd rather do that.
All right, actually, we are going to scratch that and open the hearing on Senate Joint Resolution 2. This measure urges Congress to require the United States Board on Geographic Names to consider renaming the Sheldon National Wildlife Refuge as the E.R. Sands National Wildlife Refuge. And our presenter, Senator Hansen, you may proceed when ready. Please do share your name and spell your name for the record.
Ooh, okay. I am State Senator Ira Hansen. I represent, that's IRAHANSEN. I represent District 14, which includes large sections of Elko, Eureka, and most of Washoe County, and all of Humboldt, Lander, and Pershing counties, approximately 34,000 square miles. I'm sorry, I have a PowerPoint that I got to jump to, and I need the young experts to find. Aha! We're there. I am here today to present Senate Joint Resolution Number 2. This is obviously, after the last contentious hearing, I think, Madam Chair, this is a very nice, easy one. This is about an area in northern Nevada, borders the Oregon border. I understand you read the history of it, which I thank you for. While studying, mainly I've been familiar with the area for a long time, but when the sage grouse issue was really going strong, about 4 sessions ago, I started doing a really intense study of Sheldon because it's a very unique area. And as I studied and found out the history of it, I came across this guy named E.R. Sands repeatedly. And the more I dug into it, the more I thought, man, there's a great injustice almost to this situation. So what happened was the antelope, which is, for those who don't know, I think everybody does here, but that's a picture of an antelope right there. In the early part of the 20th century, antelopes were considered on the verge of extinction. Buffalo, the passenger pigeon did go extinct in that window of time. Beaver and other populations of animals were becoming increasingly rare. In Nevada, Mr. Sands, E.R. Sands, which I'll show you a picture of, that's my next one here. Let me click on that. There he is. Kind of a college professor-looking guy at that point. But he was a biologist with the U.S. Biological Survey at that time. Nevada in 1915 had a terrible outbreak of rabies. And the U.S. Biological Survey was assigned the responsibility of basically dramatically reducing the carrier of that, which was mainly coyotes. So Mr. Sands came to Nevada, and that was his initial responsibility. In the year 1920, as part of his job, he actually went up into the northwest corner of Nevada, where eventually the Sheldon was made, and he saw for the first time antelope. He'd never seen antelope before that. That struck a chord with him, and he decided he wanted to try to come up with some way to conserve the remaining populations. So the first thing he did as head of the Biological Survey in Nevada, he went to Washoe County, to the Washoe County Commission. Now at that time, all game laws were actually controlled on the county level. So he went there and he got the county commission to agree to cancel any antelope hunting in Washoe County. He next went to Humboldt County and did the same thing. He then approached the state and got the state to cancel antelope hunting all the way across the state. Then in 1923, he convinced the governor then, Governor Scroggins, to get a bunch of refuges across the state. And one of them was what we eventually became part of the Sheldon. So he's working in that direction. The problem at that point is trying to find funding. There was no way to get the federal government aggressively involved. So Mr. Sands went to various groups. One of them at the time that was interested in trying to help preserve the antelope was the Audubon Society. The head of the Audubon Society at that time, was the small man that I got a little star above. His name was Gilbert Pearson. He was a major player nationally as the head of the Audubon Society. In that picture, if you look to his right, that is President Calvin Coolidge standing him, President of the United States at that time. That's a picture from 1923. And so Mr. Pearson had a great interest, obviously, in birds, part of the Audubon Society. And at that time, there was a federal refuge, a federal bird, I forget the exact title, but basically a refuge for birds at Antelope Island. At Anaho Island in Pyramid Lake. And Mr. Pearson got a hold of the head of the Biological Survey, Mr. Sands, and requested a tour of the island. Well, when they took him out on the island, this was in 1927, there was an Indian who had given him a ride over. Well, then the waves came up, and they ended up being isolated for one night together on that island. And at that time, Mr. Sands convinced Mr. Pearson, who was obviously a very influential person in the conservation movement, to consider coming back to Nevada, and he told him all about the need for a refuge in Nevada. So anyway, he takes him up, Mr. Pearson leaves, come back about 3 weeks later. They go up and they go to what was then called the Last Chance Ranch. On it, they observed all the antelope and stuff. And Mr. Pearson decided to, on behalf of the Audubon Society, put a down payment to purchase the ranch with the idea of creating a refuge for antelope in Nevada. So Mr. Pearson is successful in that. However, the amount of money is insufficient. So there was another huge organization at that time called the Boone and Crockett Club, which still exists, started by Theodore Roosevelt. Boone and Crockett at that time had a guy on it named Charles Sheldon. And Mr. Sheldon was, by the way, by trying to change the name, I have nothing against Mr. Sheldon. He was a major player in the United States in conservation efforts at that time as well. Anyway, the Boone and Crockett Club agreed to also put up $10,000, which is enough to buy the Last Chance Ranch and establish the beginnings of what became the Sheldon. After the Boone and Crockett money came with a little bit of a clause that they had to name it after Charles Sheldon. So that's where the name came from. So Mr. E.R. Sands at this point is delighted. You're starting to have a refuge set up. In 1931, President Hoover officially set aside what's now known as the Little Sheldon. It was the Charles Sheldon Antelope Refuge at that time. And then, so Mr. Sands at this point has succeeded. He's still involved with he's still the head of the Biological Survey. This success, the whole conservation movement is growing, and in 1936, President Franklin Roosevelt added another over 500,000 acres to it. Today, the Sheldon, it's all called the Charles Sheldon Antelope Range today. The Little Sheldon's combined. It's all under the U.S. Fish and Wildlife Service. What used to be called the U.S. Biological Survey was changed. It became the U.S. Fish and Wildlife Service. Anyway, so the last picture I want to show you real quick. This is a picture from June of 1931. There is still a sign there. This is the west boundary of the original Sheldon Antelope Range. The man standing on the left, that is E.R. Sands. And he is the man that's really responsible for that. In 1936, he became the first, he was appointed by the president to be the first refuge manager, and he lived there from 1936 until he retired in 1941. But the man on the left there basically was responsible for, in a big way, in helping save the antelope populations, not only in Nevada, but throughout the West. Also, just on the other side of the Oregon border, they created the Hart Mountain Refuge. That's another 250,000 acres, all antelope habitat. And to this day, that has been one of the great success stories in the United States. The antelope populations today in Nevada are over 25,000, where at one time that was more than they had in the entire United States. And a man like Mr. Sands, just kind of one of those unknown guys in the conservation movement, who did all these things behind the scenes, never really trying to get any recognition for it. After studying the history and all the things this guy did, he really, the refuge should get renamed for the E.R. Sands National Antelope Refuge. His very last statement that he gave, 2 days before he died, he sent a letter to the then director of the Sheldon Antelope Range. His name was Ben Hazeltine, and he said, "Hey, I'm still above ground. So I'm thinking about Sheldon," and then he died 2 days later at the age of 85. So even this hearing, which I thank you, Madam Chair, for granting, is kind of, for me, I mean, look, what this will do if we pass it, we'll send it to some federal folks who are renaming things. Whether or not they really give serious consideration to it, I don't know if they will. Just for me personally, looking back on the history of the conservation movement in Nevada, this guy was a major player in it. He helped save the antelope. He created a beautiful refuge in northwestern Nevada that's still today one of the great gems of the state. So I just thought I'd like to try to get a little recognition for one of those little unsung heroes that exist in the state. So with that, Madam Chair, I haven't asked anybody to testify this on anything. I just kind of wanted to throw that out there. So if anybody has any questions or anything, I would be delighted to do it, to answer them.
Thank you so much. I do have a question, and then I'll see if the other member has a question. So, Mr. Sheldon, I don't believe he ever lived in the state. Did he ever even visit Nevada?
Ira Hansen for the record. There's no record he ever was in Nevada. He died in 1928, just before the refuge actually began. No. Now, I will say he was influential in helping get that initial $10,000, and the agreement at that time was to name it after him. So I'm not taking anything against him because he was a major player. He was actually from Connecticut, graduate of Yale, very wealthy man, very prominent in those circles. But as far as the record shows, I don't think the guy ever set foot in the state.
Thank you so much, Senator. Okay, it looks like we have no further questions on this. With that said, would anyone like to testify in support of SJR2? Please come on up to the front. Press the microphone
Got somebody.
and share your name.
Madam Chairman and members of the committee, my name is Tina Nappy, and it's N-A-P-P-E. I didn't plan on testifying, and I will sign in afterwards, but I cannot overlook the opportunity to recognize E.R. Sands. He devoted his life to really saving Pronghorn and giving a place for Pronghorn and saving this wonderful refuge in northern Nevada. I believe that Charles Sheldon had actually died, and this was kind of a recognition of what he had done to name this refuge after him. If you go to Denali in Alaska, you will see a lot of Charles Sheldon because he helped to create that refuge as well and deserves every credit you can give him. But I don't know if this will go anywhere, but it is absolutely true that this man gave of his life without any sense of reward to create something we all enjoy today. Thank you.
Thank you so much. Is there anyone else who'd like to testify in support of Senate Joint Resolution 2? BPS, do we have anyone on the phones?
Chair, your public line is open and working, but you have no callers at this time.
Such a difference from Tuesday, huh? Would anyone like to testify in opposition of Senate Joint Resolution 2 here in Carson City or over the phones?
Chair, your public line is open and working, and you have no callers.
Would anyone in Carson City like to testify in neutral? And I'm going to take a wild stab in the dark and guess that no one is on the phones to testify in neutral. All right, that said,
Correct, Chair.
Thank you so much. Senator Hansen, would you like to make any closing remarks?
No, Madam Chair, just thank you for having the hearing.
Thank you so much. We will close the hearing then on Senate Joint Resolution 2, and we will open the hearing on Senate Bill 141. This measure revises provisions related to wildlife, and since our presenter is already seated, we'll proceed when he is ready. Thank you so much, Senator Hansen.
Thank you, Madam Chair. Ira Hansen again for the record, Senate District 14. This one, not really controversial initially, but there's been a little bit of controversy about it. What this bill hopes to do is change NRS 502120 and allow, well, let me back up. The current law requires a hunter, fisherman, or trapper, or anyone that's licensed by the Department of Wildlife in those areas to carry that physical license with them. Right now, in fact, I've got my wallet, and in it I've got my hunting and fishing license right here, and that's the physical copy. Now, all I wanted to do with the bill...
Don't go hunting in here, though.
Only wild horses, yes. No, I won't do that. Don't have a tag for it. Anyway, my whole intent with this bill was simply to allow those to be, instead of hard copies, to be electronically as well. Not to eliminate the hard copy, but simply to make it so like everything nowadays is in your cell phone. And Senator Flores, I think there may be a bill you mentioned possibly to deal with driver's licenses as well. You can do it right now with your insurance cards as well. So there is some precedence to it. And as things become increasingly electronic in our world, I mean, since I've been in the legislature, this is my 7th session, I don't know how many times we've had bills just bringing things up to allow electronic transfers of data and so forth. And so this is really just kind of catching up with the technology that the younger people in particular use constantly. And also, when I'm out in the field, now technically, you are supposed to have the physical license with you while you're doing that. There has been a certain level of flexibility. The reason this bill came about was my son-in-law was actually fishing not too far from the Sheldon, actually, on a place called Wall Canyon Reservoir, and out in a boat. And anyway, a warden showed up and called him in and asked him if he had his fishing license on him, and he did not. He actually had it in the truck, and they got a little extra that he's supposed to physically have it on his possession, and he could be cited for that, but he wasn't going to do it. And I said, that's kind of silly. So in this day and age, when everything is electronic, the purpose of this is to do that. Now, this morning, I have an apology, and that is I have a conceptual amendment that we're working on. I talked to Alan Genet, the new head of Department of Wildlife, and I forget the guy's name, his head law enforcement guy. They both said they're already allowing that. Okay, it's not in the law, but they already allow it. I could, if I was in the field and I had taken, he said, you can take a picture of your physical license, put it in your phone, and if a warden asks to see your license, you can show him, not the physical copy, but in fact an electronic one. So that's the main purpose of the bill, and I will have to do a conceptual amendment, and I'll explain why the conceptual amendment is coming up instead of the original concept. As I got into this, we actually had a hearing on another bill, and in it, they were changing the wildlife laws. It was actually in growth and infrastructure. And in it, they brought up that they were bringing up the boating statutes and adding a section of the law which is similar to the one in 502120. Now, this law right now, this is what it reads. Each person required to have a license or permit as provided in this title, who, while engaged in any activity regulated by this title, refuses to exhibit the license or permit, any wildlife which the person may have in his or her possession, or any weapon, ammunition, device, or apparatus in his or her possession, which may be used for any activity regulated by this title, upon the demand of any officer authorized to enforce the fish and game laws of this state, is guilty of a misdemeanor. Now, that was a red flag for me, because as past chair of the Judiciary Committee and having served on Judiciary, there are some real sensitivity issues revolving around your right to the Fifth Amendment right against self-incrimination. Okay? So what happened is I talked to the public defenders, and I talked to the DAs, and I talked to the wildlife people, and they were supposed to send me some stuff today, but they haven't done it quite yet. Bottom line is this. You have a right under the Fifth Amendment and under the Fourth on search and seizure, you have a right to not cooperate, frankly, with law enforcement when they start asking you certain questions. For example, you do have, and there, on your desk in front of you is a copy of a United States Supreme Court decision. Interestingly enough, it was based on a Nevada case in my district, actually, Grass Valley, in which a gentleman named Mr. Hibble, there was a domestic dispute, law enforcement was dispatched, Mr. Hibble apparently was involved in it. The officer found Mr. Hibble refused to cooperate in any way, shape, or form. And Mr. Hibble then sued when he was given a citation under Nevada law, the section, well, it's a similar section to this, I've got it right here somewhere, but the point is Mr. Hibble was given a citation for hindering an officer. Went all the way to the United States Supreme Court, and the Supreme Court, in a 5-4 decision called Hibble versus the state of Nevada, basically, Mr. Hibble, the 5 justices, the conservative justices on the bench, said Mr. Hibble does have the legal responsibility to provide his identification to the officer. The other 4, which included Judges Ginsburg and the other liberal wing, said no, Mr. Hibble has, under the Fifth Amendment, a right against self-incrimination, and that would include identification. Nevertheless, the law clearly was you have to provide identification. The law, however, had 2 interesting points to it. One is that identification can be simply a verbal, I am Ira Hansen, nothing more. Also, for the officer to be able to stop you and ask for your identification, he has to be involved in some level of criminal observation. In this case, it had been a domestic dispute, and the Supreme Court justices agreed that that is a legitimate reason to stop Mr. Hibble and question him. However, you cannot randomly, even now, stop the highway patrol if they were following the chair in Washoe Valley and you were not doing anything wrong. They don't have the right to pull you over unless there is some evidence of criminal activity. Now, that also applies in wildlife law. Your right against self-incrimination and the ability for people to force you to provide an identification is just as much protected when you're out in the field in an urban setting, a rural setting, as you would be under the situations like Mr. Hibble was involved in. So anyway, the Supreme Court said, number one, you do have to provide identification. It can be as simple as, I'm Ira Hansen. They do not have the right under Hibble to force you to provide like a driver's license, for example. That is not allowed. That would be considered, they can ask, but Mr. Hibble, in this case, would have the right to not provide that. All he had to do was say, I'm Mr. Hibble, and that's as far as it goes. Now, if you'll notice the Nevada statute, if in fact you exercise your First Amendment right against self-incrimination, then you can be cited for doing so. So, anyway, I had a bunch of folks from all the legal scholars, and talking to Mr. Flores, who's a lawyer, and I was hoping Melanie would be here too. The bottom line is this: we should never have a law that punishes people for exercising a constitutional right. You also, under the Fourth Amendment, have a right against unreasonable searches. That's why if, for example, if a warden was to approach me in the field and he had not observed me doing anything that could potentially be something he needs to investigate, he actually does not have the right to come to me and demand that I produce my hunting license or fishing license. He does not have the right to demand that I show him my weapon or any animals I have or any apparatus that I might have. And now he can ask, but if I, in fact, say, no, I don't want to talk to you, I want to talk to a lawyer, my name is Ira Hansen, and he says, well, you better answer it, because if not, you're hindering my investigation, and that is a misdemeanor in Nevada. Now, misdemeanors, I'm sure you know, I could go to jail theoretically for 6 months and be fined $1,000. In that case, I would be doing that while exercising a fundamental constitutional right as established by Hibble by the United States Supreme Court. Anyway, so all that for going from an electronic license, we now have a serious constitutional question. What I am doing, Madam Chair, is I have a conceptual amendment that I'm working on as we speak to address the Fifth Amendment concerns that were addressed in Hibble, and to actually get in law. If somebody wants to come and question me, whether I'm driving down the highway, or if I'm standing in a river fishing, for law enforcement, any law enforcement, not just game wardens, but any law enforcement to come and approach me and demand that I provide identification, and I do anything, and they demand anything beyond, what's your name? I'm Ira Hansen. I don't want to say any more. I'm not going to show you my license. Okay, well, you understand you are hindering me in my investigation, and I will write you a citation for that, for your failure to do the steps that are outlined in 502-120. Interestingly enough, in the hearing on the other bill, Senator Spearman was sitting here, and she asked the warden at the time, well, because it's basically the same language that's going in the new law dealing with boating laws. And she asked, if I told you my name and then I didn't provide a license, what would you do? And he said, well, I'd give you a couple minutes, and then I would cite you for hindering my investigation. And we're all like, well, that's interesting, because you do have a right to remain silent under the Fifth Amendment, as I understand it. Like I said, today I talked to the law enforcement people at Endow, and they're going to provide me some stuff that their Deputy Attorney General gave. But anyway, that's the gist of the bill. The point, I will work on getting an amendment on addressing that language further to make sure that we don't have anything in Nevada statutes that would in any way, shape, or form violate anybody's Fourth or Fifth Amendment rights. And I will also get, apparently it's already going on with the department, but I will get the language drafted that you could have both a physical or an electronic copy of your license when you are engaged in any of those activities. And that's pretty much the sum of my presentation today. Thank you, Madam Chair.
Thank you so much, Senator, and I would like it on the record that you applauded one of Justice Ginsburg's decisions.
Well, Madam Chair, if you look in the handout, I actually, in that little bullet point one, I quote no, she was, just so you know, I know you guys think because I'm a Republican and very conservative, the ACLU and Ira Hansen, believe it or not, get along great on a lot of issues. I'm a big champion with the Public Defender's Office. After serving as chair of Judiciary and getting to learn both sides of how law enforcement really works, one thing you very quickly learn is that the deck is very much stacked in favor of the prosecution, including in Nevada. It is glamorous to be a district attorney. It is not glamorous to be the public defender. And that filters right down to how our criminal system works. And for people who are, especially people that don't have the financial means to fight back, it's very frightening. Like, well, I won't get into the weeds, but in 2015, the Department of Wildlife cited me while I'm an assemblyman, and I ended up having to fight it. And I was found not guilty, but I had to pay $10,000 to my attorney to do so. And the district attorney had offered to say, you plead guilty, pay $100, and you can walk away. I said, no. Frankly, I said, go to hell. I'm not guilty of anything. So that was just prior to becoming chair of Judiciary, and we had a bunch of bills, ironically, to take away some of the powers of the Public Defender's Office. And at that time, the current speaker, Mr. Yeager, was the public defender lobbyist, and Jason Frierson actually was defeated, but he was still involved in that, called me personally and said, man, you can't do that. In fact, Mr. Yeager, Speaker Yeager, told me that if we passed that law, he would resign as being a public defender. So that's a learning curve, and that's why when it comes to the ACLU, Justice Ginsburg, people that traditionally work very hard to make sure that your constitutional rights are followed completely, including the Fourth and Fifth Amendments, we're on the absolute same page. That's also why I passed out little pocket copies of the Constitution. I always carry one in my own pocket, and when issues like this come up, I'll read, what does the Fourth Amendment say? What does the Fifth Amendment say? So Justice Ginsburg and right-winger Ira Hansen, we'd get along pretty good on some issues. Thank you, Madam Chair.
Thank you so much. Senator Flores, did you have any questions?
Thank you, Madam Chair, and thank you, Senator, for bringing this bill. I'm trying to draw an analogy, and it's not apples to apples, so it's not fair. But you're engaged in the activity of hunting or fishing, and it's the act of being engaged in that activity that would then trigger somebody who has some authority to regulate that activity to say, you're engaged in that. And I draw an analogy to maybe operating a motor vehicle. That would then trigger somebody who has the authority in law enforcement to say, you have to have a driver's license in order for you to operate a vehicle. And here, that would trigger that officer to say, you have to have a license to fish or hunt, XYZ. So I'm just trying to understand the concern you had. Is it that what you're seeing happening is that because there's a rebuttable presumption in here, I think in the current NRS, that if you do get a fine, you just go to court and you show them that you actually had a license. You just didn't happen to have it on you that day. Yeah,
that's correct. Now, that's on just the license portion of it.
Right.
All the other stuff, that doesn't apply.
And so, and maybe the question will be better if I engage with, should there be an opposition, maybe I could ask more direct questions there. But I'm just trying to understand, the big concern is, are you coming at this specifically through the mindset of, let's just be efficient. You should be able to have it on your phone. You could be able to show it on the spot and avoid the need to go through getting a ticket, rebuttable presumption, court, and avoiding that whole step. Is that the bottom line, what you were trying to get at? Or, because I know you also mentioned the other scenario that you went through, and so I'm just trying to understand what the bottom line for you is with this particular bill.
Well, the bottom line was, Ira Hansen again, your original point is absolutely what the bottom line was. That was simply to allow it. So, because right now, the law, the way it reads, you couldn't use an electronic one. Now, NDOW told me today they are doing that. So, I guess it's somewhat of a moot point. But now what branched out, though, was when I read the whole statute and then applied it to, okay, where are we on the criminal justice side of things? Now, honestly, I hadn't been thinking about this until that hearing the other day, and that's why I apologize for this being a conceptual amendment. bottom line is any activity before a law enforcement person in any respect, whether it's a warden or a highway patrolman, can pull you over and stop you and demand to see a specific document on you, there has to be some level of reasonableness. Of what has they observed me possibly doing something illegal? That's the whole concept of unreasonable searches. It's reasonable if they're watching me and I've put 15 trout on my stringer, and they know the limit's 5, and then they come over and say, what's your name? Hanson. Hey, Mr. Hanson, can I see your license and so forth. Now, even at that point, remember, you have the right to not incriminate yourself. So if, in fact, in that scenario, somebody's got 15 fish, they're supposed to only have 5, the state has the burden of proving every element of that crime. And if you, in fact, say at that point, I'm not talking to you, my name's Ira Hanson, you can do what you want, but, you can go through my attorney. That's completely within your right of exercising your right to not self-incriminate yourself. Your right to, as we would say, your right to remain silent. And that is a fundamental right. The state has to prove every element of a crime. And if you are being forced under a possible misdemeanor criminal citation to provide the very evidence that will then be used against you in a court of law, I don't know any better definition of self-incrimination.
And thank you for that, Madam Chair. And I was trying to just draw an analogy because based on the conversation we've engaged in, you would be concerned if law enforcement was pulling over every vehicle just to make sure that they had a valid driver's license, which is you're concerned. You'd be concerned that everybody who's engaged in the activity of fishing or hunting or whatever it may be, that they're in essence, by drawing that analogy, pulling everybody over just to make sure you have a license. And I just wanted to kind of draw an analogy because we could see this if applied in other areas. We could possibly be concerned if that became the norm. So I just wanted to kind of use a...
No, well, your analogy, Ira Hansen again, your analogy is completely right. In fact, what's been interesting is the issue of driver's licenses and being pulled over. You talk to Dallas Harris, you talk to Pat Spearman, you talk to Chandra Summers Armstrong, and they are convinced that the law enforcement community disproportionately pulls over black youths driving automobiles without probable cause. And that's why I was talking to Dallas about this. She's very much aware of the potential abuse, but also the protections. That's why a policeman cannot randomly do that. Now, you're a lawyer. You remember there used to be vagrancy laws in the United States, loitering laws. They eliminate all those. The policeman used to have the ability to come up to somebody randomly in Sparks, Nevada, and ask them, hey, what's your ID? What are you doing here? Are you loitering? Do you have a job? And literally run them out of town. That obviously is the past, but that concept is still there, and it can be very dangerous for law enforcement. That's why we need some controls on that, and that's why you have the decisions like Hibble, which was really, when you think about it, a minor thing. A policeman basically stopped a guy and asked for his ID. That made it all the way to the United States Supreme Court, and whether or not Mr. Hibble even had to give his name was a 5-4 decision with Justice Ginsburg saying, no, he doesn't even have to do that. That's an act of self-incrimination. So anyway, I don't want to belabor it too much, Madam Chair. I will be working on a conceptual amendment. Oh, I'm sorry. Senator Flores, if you have any other things, I'd be happy to try to answer them for you. Would any of the other members of the committee like to talk to me? No.
Thank you so much. With, as you know, judiciary going a bit long, some of our other members are unfortunately unable, and to our committee secretary, if Senator Scheibel does not make it, please mark her absent excused, since she is still in judiciary.
Well, there you go. Pete, you're a lot more handsome and better looking now. Actually, Madam Chair, I'm supposed to be in judiciary, so I snuck out.
Yes, and thank
that's
you
all
for
right.
being here to present
Thank
today
you for the hearing.
and to be here in committee. I guess the only thing that comes to mind, probably similar to what Senator Flores was mentioning, is when stopped by law enforcement, when driving a vehicle, a motor vehicle, of course, we can't have a digital copy of our driver's license on hand. So I do draw that parallel, and I didn't know if you had any thoughts regarding that. And again, I know it's not necessarily a fair thing to ask you because that's not what your bill entails, but it was the first thing that occurred to me.
No, it's actually a completely fair thing. It is kind of interesting because in our society now, we need some kind of a physical identification, and driver's licenses are typically it. Interesting enough, on my hunting license, I know when I applied, I had to give my social security number and my Nevada driver's license number. So that's actually on that document as well. I believe. I have to double check that. It's a completely fair analogy, and as Senator Flores mentioned, we may want to, before the session ends, come up with some way to allow a digital one. I mean, honestly, there is a little bit of a difference, and that is if you're driving a vehicle, you will always have the ability to have a license with you. There's always room in a car for at least a little card. When you're out in the hills in a boat, or my son-in-law fishing, you don't want to have your wallet out there, all right? Thing tips over, lose your stuff, things fall out. When you're hunting in the hills, one of the reasons I don't carry my wallet is because I've had the unfortunate experience of losing my wallet while on a hunting trip. So the analogy is close, but not exactly right. But the whole idea of allowing driver's licenses to be digital, I think that's an excellent idea. And certainly I think that's a direction we should go as a legislative body, just to make things a lot simpler for the citizens of the state.
Thank you, Senator. And with that, unless there's any further questions from committee member,
Committee member?
we will hear testimony in support of Senate Bill 141.
Good afternoon, Madam Chair and committee members. For the record, my name is Steve Walker, Stevewalker. I'm representing Eureka County. Eureka County is in support of the bill as written. We have not seen the amendment, and so we think that it's a very good bill. I personally would like to ask Senator Hansen to maybe take his abundant energy and get it done in California, where I fish most of the time, and because there you have to have your license prominently displayed on your outside so they can see it with a spotting scope. And I don't know if that's still the rule, but it has been. So, yeah, if you could get it changed there, I'd appreciate it. Thank you.
Thank you so much. Any other testimony in support? BPS, do we have anyone on the phone lines?
Chair, your line is open and working, but you have no callers at this time.
Thank you so much. With that, unless I see anyone else coming forward in support, is there any testimony in opposition? Seeing none here in Carson City, has anyone miraculously joined the phone lines in the last 30 seconds?
Chair, you have no callers at this time.
All right, anyone here to testify in neutral? BPS, one last chance. Anyone on the phone lines?
Chair, you have no callers at this time.
Thank you so much. Senator Hansen, would you like to make any closing remarks?
Just to thank you, Madam Chair, for giving me this hearing, and to let you know that that conceptual amendment will be drafted soon, I hope, and I'll circle back around to you when I have that. Thank you very much.
Thank you so much. And with that, I will now close the hearing on Senate Bill 141. And this meeting is going a little bit more quickly than Tuesday's meeting, and we're now on to public comment, which is our final order of business. As a reminder, public comment does not include comment regarding any of the bills we heard today and is limited to 2 minutes per person. However, always feel free to submit additional written comments to the secretary, and it will be added to the record. Do we have any public comment in Carson City? BPS, has anyone joined us over the phones to make public comment?
Chair, you have no callers at this time.
Thank you so much. Seeing no public comments, this meeting is adjourned.